Hello and welcome to Workers' Comp Unwrapped, the podcast that simplifies workers' compensation for physicians. I'm your host, Max, here to give you clear, actionable insights to navigate the medical legal side of workers' comp. So let's get started.
Yes.
It can be tricky for doctors dealing with workers' comp.
Right.
It sounds simple, but like that bookshelf from a certain Swedish furniture store,
Oh, yeah.
Miss one step and the whole thing falls apart.
Totally.
So Aisha, let's break it down for all the hardworking doctors out there.
Yeah.
What exactly is a DOR, and why is it so important to getting paid what you're owed?
Well, a DOR is basically your way of telling the Workers' Compensation Appeals Board in California that you are ready for a hearing, you've done everything you're supposed to do, and you want a judge to help move the case forward. It's super important because it sets the whole legal process in motion.
Okay, so it's the official let's settle this thing document.
Yeah.
No more waiting around for the insurer to do the right thing.
Yeah, exactly. You're letting them know you're prepared and you're serious about getting a resolution.
No messing around. Got it. But before our doctor friends rush off to file a DOR, what are some absolute must-dos? What's the prep work like?
That's where it gets interesting. The key here is something called good faith efforts.
Ooh, that sounds intense.
It's not as scary as it sounds.
Yeah.
Basically, you have to prove that you've made a genuine effort to resolve the issue with the insurance company before going for a hearing.
So kind of like couples counseling before divorce court.
Exactly. You have to show you've tried to work things out. This means documenting every attempt to communicate and negotiate with the insurer.
Every single email, phone call, fax. Everything.
Every single one. Those records are crucial evidence if the case ends up in front of a judge.
Okay, noted. So you're saying documentation is key here. What else falls under this good faith effort umbrella?
Another big one is making sure discovery is complete.
Discovery. Is this where we put on our detective hats?
Not quite. It means all the medical reports, diagnostic studies, witness statements, all that juicy evidence needs to be exchanged with the insurance company before you file the DOR.
Ah, so it's like laying all your cards on the table, no surprises.
Precisely. Everyone knows what they're dealing with, and you're showing that you're organized and ready to proceed.
This is where I imagine things can get tricky for doctors.
Mm-hmm.
What are some common pitfalls they should avoid, especially if they want to make sure they get paid for their services?
You are absolutely right. This is where we see a lot of doctors stumble, especially those in specialties like orthopedics or pain management.
What makes those specialties more prone to issues with the DOR?
Insurers tend to scrutinize those cases more closely. They often question whether the treatment was really necessary and whether the costs are justified. So your documentation has to be absolutely impeccable.
So every single detail needs to be there to justify the treatment plan? No cutting corners?
No. Exactly. Think of it as building a fortress around your case. The more solid evidence you have, the stronger your position. Every single office visit, every procedure, every prescription needs to be clearly documented and connected to the workplace injury. No gaps, no missing pieces. Otherwise, the insurer might object, claiming the treatment wasn't justified, and that could delay your case, or even worse, lead to denial of reimbursement.
Ouch. So for our orthopedic surgeons and pain management docs out there, what kind of documentation is absolutely essential?
For orthopedics, detailed operative reports, imaging results, those are crucial. For pain management, a solid, well-documented treatment plan is key. You need to be able to justify why ongoing care is necessary and how it's helping the patient recover.
So it's not just about treating the patient, it's about building a rock-solid case with your documentation to make sure you get paid for the important work you do.
Absolutely. Your notes are your strongest weapon in the workers' comp world.
You get?
And they can be the difference between getting paid and not getting paid.
Okay, so we've covered the importance of good faith efforts and complete discovery. Now let's get down to brass tacks. Aisha, walk us through the step-by-step process of actually filing a DOR.
All right, so step one, you got to get your hands on the DOR form itself. You can download it straight from the California Division of Workers' Compensation website.
Easy peasy. But I'm guessing it's not as simple as just printing it out and scribbling some answers.
Nope. Attention to detail is your best friend here. Make sure you fill out every single section accurately and completely. We are talking WCAB, case number, applicant's name, date of injury, a clear and concise description of the unresolved issues. No room for vagueness here.
So if the dispute is about unpaid medical bills, we need to be specific about those bills, not just, oh, they owe me money.
Exactly. List the dates of service, the procedures, the exact amounts owed. Don't leave anything to chance.
Noted. And this is where all that good faith effort documentation comes into play, right?
You got it. This is your time to shine. Describe every attempt you made to resolve the issue with the insurer. Dates, times, methods of communication, and don't forget to attach supporting documents.
So email chains, phone records, letters, all that good stuff.
Exactly. Think of it as building a fortress around your case. The more evidence you have, the stronger your position.
So what happens after we've painstakingly filled out the DOR form and gathered all our supporting documents? Where does it go?
2 places. You submit the original to the WCAB, and you serve a copy to the opposing party. Make sure you keep proof of service just in case they claim they never received it.
Smart move. So once the DOR is filed and served, are we good to go? Is it smooth sailing from there?
Well, not always. This is where we sometimes hit a speed bump called objections.
Objections? Sounds ominous. What are those all about?
The opposing party, the insurer in this case, can file objections to your DOR if they believe something is not right. It could be anything from discovery isn't complete to good faith efforts were insufficient.
So it's basically a legal way of saying, hold on a minute, we're not ready to tango.
Exactly. And these objections can really throw a wrench in your plans. They can delay the case, lead to additional hearings, and even get your DOR dismissed.
So how do we avoid getting tripped up by these objections? What are some common ones that doctors need to watch out for, especially if they want to avoid leaving money on the table?
The most common one by far is the discovery isn't complete objection. This is where those meticulous records come in handy. You need to be able to prove that you exchanged all necessary documentation with the insurer.
So basically, if the insurer says, hey, we never got that MRI report, we can hit them with, oh, yes, you did. Here's the proof of service.
Exactly. That's why keeping detailed records of every single communication is so crucial.
So it's like a legal game of chess. Anticipate their moves and have a counter move ready. Always be one step ahead.
You got it. Another common objection is good faith efforts were insufficient. This is where that detailed documentation of every attempt to resolve the issue becomes your saving grace.
So if the insurer claims you didn't try hard enough to work things out with them, we can whip out our phone logs, emails, letters, and say, excuse me, but we did everything we could to resolve this before filing the DOR.
Precisely. You have to be able to prove that you made a genuine effort to reach a resolution before resorting to a hearing.
This is all starting to make sense. Now, Aisha, I know you've seen your fair share of DOR drama in your 15 years of experience. Can you share some real-world examples to illustrate these common pitfalls? Stories that will make our listeners say, oh, wow, I'm glad that wasn't me.
Absolutely. One case that comes to mind involved a provider who filed a DOR without including any treatment authorization requests or denial letters.
Wait, so they just filed the DOR without any documentation to support their case? That's like showing up to a potluck with empty hands.
Yep. They thought it was enough to just state that there was a dispute over medical bills.
Big mistake.
Huge mistake. The insurer immediately objected, claiming there was no evidence of any actual dispute. The WCAB sided with the insurer, and the provider had to start the entire process from scratch.
Ouch. So lesson learned, always attach those supporting documents. Your DOR is only as strong as the evidence you present.
You got it. Another case involved a claimant who filed a DOR without completing discovery.
So they jumped the gun and tried to go straight to the hearing without laying all the groundwork. That's like trying to bake a cake without any flour.
Exactly. The opposing party objected, and the WCAB ordered the hearing off calendar. The claimant had to go back, complete discovery, and refile the DOR, which caused significant delays.
That sounds like a major headache and a lot of wasted time and money.
It was. And it could have been easily avoided by simply following the proper steps and completing discovery before filing the DOR. No shortcuts in workers' comp if you want to get paid what you deserve.
All right, so we've covered the importance of good faith efforts, complete discovery, accurate DOR filing, and avoiding those pesky objections. But let's dive a little deeper into those specialty-specific documentation requirements. Aisha, what are some key things that orthopedic surgeons, dentists, pain management specialists, and psychiatrists need to keep in mind to make sure their DOR is bulletproof?
For orthopedic surgeons, detailed operative reports are absolutely crucial. Every step of the surgery needs to be clearly documented along with any implants used and the rationale behind each decision.
So it's not just about saying, we fixed the broken bone. It's about painting a detailed picture of the entire surgical process. So there's no room for the insurer to say, well, we don't think that surgery was really necessary.
Exactly. You need to show the complexity of the procedure and how it directly relates to the workplace injury.
And I'm guessing imaging results are also crucial in these cases.
You bet. X-rays, MRIs, CT, scans, all of these need to be included in the DOR package to support the diagnosis and treatment plan.
Got it. So orthopedic surgeons need detailed operative reports and imaging results. What about dentists? What are some common DOR challenges they face?
For dentists, the biggest challenge is often proving that the dental issue is directly related to the workplace injury.
So if someone chipped a tooth at work, it's pretty straightforward, but what if it's a more complex dental problem?
That's where things get tricky. Let's say a worker develops TMJ disorder after a whiplash injury at work. The dentist needs to provide clear documentation linking the TMJ problem to the whiplash incident.
So detailed records of the patient's symptoms, the mechanism of injury, and any pre-existing dental conditions are essential to build that clear connection and make sure the dentist gets paid.
Absolutely. And of course, x-rays are crucial to show the extent of the dental damage.
Got it. Detailed records, x-rays.
Oh.
What about our pain management specialists? What do they need to focus on?
For pain management doctors, a well-structured and thoroughly documented treatment plan is key. You need to be able to justify every medication, every injection, every therapy session.
So it's not just about prescribing painkillers. It's about developing a comprehensive approach to managing the patient's pain and helping them regain functionality.
Yeah.
And documenting all of that meticulously.
Exactly. And documentation needs to clearly show how each treatment modality is addressing the specific pain caused by the workplace injury.
Got it. So for pain management, it's all about detailed treatment plans and justification for each intervention. What about psychiatrists? What are some common DOR issues they encounter?
For psychiatrists, the challenge often lies in establishing a clear link between the mental health condition and the workplace incident.
So if someone develops PTSD after a traumatic workplace accident, that connection seems clear. But what if it's a more subtle mental health issue, like anxiety or depression?
That's where things get more complex. Let's say a worker develops anxiety and depression after a prolonged period of workplace stress. The psychiatrist needs to provide detailed evaluations linking these mental health symptoms directly to the workplace stressors.
So thorough patient interviews, psychological testing, and a comprehensive analysis of the workplace environment are all important pieces of the puzzle to show that the mental health condition is a direct result of work.
Exactly. And documentation needs to be detailed and persuasive to support the claim that the mental health condition is a direct result of the work environment.
Wow, Aisha, this has been incredibly insightful. I'm starting to see why you're the DOR guru. You're like a DOR whisperer.
Well, I wouldn't go that far.
Oh, I would. You've broken down this complex process into clear, actionable steps and given our doctor friends valuable tips on avoiding those common pitfalls. But before we wrap up this part of our deep dive, I want to touch on one more important topic: industry trends and how they're impacting the DOR process. What are some key changes that doctors need to be aware of so they can stay ahead of the curve and maximize their chances of getting paid?
One major trend we're seeing is an increased emphasis on mediation and alternative dispute resolution.
To try to resolve things amicably before going to a hearing, like trying to settle things out of court.
Exactly. It's more efficient, less stressful, and often saves everyone a ton of money. Some WCAB offices are even actively encouraging parties to explore mediation before filing a DOR.
Interesting. So it's like adding an extra step to the process, but with the potential for a smoother outcome and a faster resolution, which means doctors can get paid sooner. But what happens if mediation fails? Do we just go back to the good old DOR routine?
You got it. But here's the catch. Even if mediation doesn't work out, you still need to show that you made a genuine effort to resolve things. In fact, the WCAB is getting stricter about enforcing good faith efforts, even more so now with this push for mediation.
So it's like they're saying, hey, we're giving you more tools to settle things early, so don't come crying to us with a DOR unless you've truly exhausted all other options.
You nailed it. We've seen cases where DORs got tossed out simply because the moving party couldn't prove they genuinely tried to negotiate or mediate beforehand.
Wow, that's a tough lesson to learn the hard way. So for our doctor friends listening, the message is clear. Document every conversation, every email, every attempt to find common ground. Those records could be your saving grace when it comes to getting paid.
Couldn't agree more. And speaking of trends, let's not forget about the elephant in the room technology.
Ah, yes. The digital revolution is upon us, even in the workers' comp world. What kind of impact are we seeing on the DOR process?
Well, for starters, more and more things are being done online, filing documents, scheduling.
Thank you for listening to Workers' Comp Unwrapped. If you found value in today's episode, share it with your fellow medical providers and healthcare specialists. For more information, contact us at lena.klein@medicallienmgt.com or visit our website, medicallienmgt.com.